Justice.
Please take your seats. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Barbados, CCJ Appeal number 7 of 2018, between David Brooks versus Alistair Lindsay Morris, the executor of the estate of Henry Newitt. The hearing of the appeal this morning. Can we have the appearances for the court, please? Thank you.
May it please the court, I'm Brian Weeks and I appear on behalf of the appellant, Mr. Brooks.
Please the court, I'm Hazelyn Definish and I appear on behalf of the respondent, Alistair Morris.
Yes, good morning, counsel. Mr. Weeks, are you ready?
I am indeed, Your Honor. May I proceed?
Yes, please.
There seems to be a slight delay, so, Your Honors, as I embark on the arguments with the appellant, I want to make it clear from the outset that I do not intend to take up too much of the hour to which I've been allocated. The appellant will rely very heavily on his written submissions to the court which have been filed, and in his reply to the submissions of the respondent. At the outset, I would want to inquire from the court if there are any issues with which I can assist arising out of the written submissions as filed on behalf of the appellant.
If I may take you up, Mr. Weeks, it is my understanding, and I commend both sides for their written submissions, that the matter has now, as it were, boiled down essentially to whether there is to be implied a term that 75% of the money should be returned on the basis that the parties impliedly agreed that the limit of the damages would be the 25%. Is that the essence of the case now?
That is very much one of two very important issues. We definitely pursue that as one of them, and our position, quite frankly, is that based on the type of agreement, the circumstances which attended the formation of the agreement, our submission is that the courts can, in fact, imply such a term. But in addition to that issue, the issue as to the treatment of the law of deposits as well is very much in focus in this appeal, because it is rare that a party finds themselves in the position that Mr. Brooks and his family found themselves in, where 100% of the money that was payable for the rental of that holiday accommodation had been paid up front, so that there is actually an even more nuanced position as it relates to the law of deposits, because it is clear on the face of it that 25% of the prepayment was to be treated as a non-refundable deposit. That much is clear and has been accepted by both courts below. But in addition to that, the question of when a sum of money becomes in law a penalty is also relevant here, because essentially, because Mr. Brooks had paid 100% of the consideration for the rental accommodation, the owner of the property basically had a payment which in law would be termed in terrorem. In other words, he had performed, that is Mr. Brooks, had performed everything asked of him pursuant to the agreement that they had entered into. Now, one of the reasons why, going back to the implied term argument, that I humbly submitted to the court that the court needs to look very carefully at is the type of contractual arrangement and the circumstances. Because what essentially happened in this case was that a family from California in the United States, based on representations which had been made online, prepaid 100% of their holiday for accommodation. And I would humbly submit to the court that when it comes to accommodation, there can be any number of reasons why persons in the position of the Brooks family may choose upon arrival at their destination not to avail themselves of the accommodation. It could be something as simple as in the tropics there may be, a plant that they happen to be allergic to. Any number of reasons could arise as to why they could or choose not to stay. And that is why in circumstances, the law treats to situations where people have made significant, if not 100% prepayments, enjoy some degree of protection. So,
Mr. Weeks, could you just clarify one point before you go further? You said it was unusual for your client to have paid 100% of the consideration. Why did he pay 100%? Was he required to do so by the contractual arrangements? Was there some other reason?
No, that was one of the terms of the arrangement, and I can take your lordship, the court, to that part of the record if you require me to. But essentially, the conditions for the contract were set by Mr. Newitt, a 25% non-refundable deposit, and the rest payable 8 weeks before arrival in Barbados.
So now, if that is the case, why then do you say it was unusual? I mean, it was part of the contractual arrangement between the two parties.
Yes. The fact of the 100% prepayment is not, perhaps unusual is not the best way of describing the situation. The reason why I think that that someone in the Brooks family may not have been terribly uncomfortable paying all of their money was that there was a term expressed that 25% of it would be non-refundable in any circumstances. They agreed to that. So this is why we say that there is to be implied into the contract, because it was an accommodation sight unseen and 100% of the money paid up front, that any reasonable person entering into that arrangement would say to themselves, look, if I arrive in Barbados and there's something amiss with the accommodation, I give up 25%, which is fair, which the Court of Appeal actually held to be a fair prepayment given the industry that the owner of the property was engaged in. But one would expect a refund of the 75, because to do otherwise would be really to force the family to stay in that accommodation. Now, thankfully for the Brookses, they were in a financial position where they could move on to another holiday accommodation in Barbados, and they were able to spend their Christmas of that year here.
But Mr. Weeks, Mr. Weeks,
yes, yes, sir.
You were looking at this, and I could understand why you would do so, because you represent the appellant. But you're looking at this purely from the appellant's standpoint. Try looking at it as well from the respondent's standpoint. They make their place available, and they expect to receive a certain sum of money for a particular length of time. And then at the 11th hour, they're told, well, no, we don't want it again, so we want back 75% or whatever percentage of our funds. So won't they suffer a loss unless at that late stage they are able to get an alternative tenant?
Well, I'm accustomed to addressing the court as Malad, so forgive me if I slip into that usage. Your Honor, that is a very good question, and that is why in the appellant's written submissions we took great care to treat to the law as it relates to how deposits are treated, and the law is developing in a way that deposits are treated very much as a form of liquidated damages. In other words, Mr. Newitt guaranteed himself by the use of the term non-refundable and deposit.
No, there was another term that he used as well, you know. He said something along the lines that this was to secure the place.
Well, that is usually the purpose for most deposits, Your Honor, where it forms part of the purchase price. For a deposit to be treated as a deposit in the truest sense of the word, it has to form part of the overall consideration for the arrangement. So that what we say is that when you in your language, in your contractual language, use the term deposit, it has certain legal consequences. And in this particular case, because not only did the parties use the term deposit, they used the term non-refundable deposit. So that our counter to the issues raised by the court is that if this contract had not included a deposit, a non-refundable deposit of 25%, then yes, the failure of the Brooks family to stay and to pay for the accommodation would attract the usual method of calculation of damages, because Mr. Newitt would have been entitled to notice, he would have been entitled to some compensation for the loss of the rental income, and so on. But the distinguishing factor here is that a sum of money, 25%, which is higher than it would normally be expected to be a deposit, but which our Court of Appeal held, and we agreed, because that is what we submitted to the court, was a perfectly legitimate deposit in the circumstances. But we go further. We say that the Court of Appeal erred in the treatment that it gave, having found that 25% was a non-refundable deposit, because it was not refundable and forfeitable by Mr. Newitt. Our submission goes further. The law then requires, how does the treatment of what otherwise would be a payment on account, the family not having yet arrived in Barbados, what is to become of that 75% prepayment? And this is why we say that there can be...
Sorry. You are eliding the distinction between the deposit and the 100% prepayment. And it seems to me your difficulty is you cannot convert that prepayment into a deposit.
No. Usually, Your Honor, in most transactions, and the easiest by way of analogy would be a deposit paid in an agreement for the purchase of land, certainly
with the greatest of respect, that absolutely does not have any attraction or comparability for me in terms of 100% prepayment for accommodation.
Okay, so if the term is, if the prepayment, forgetting the actual contractual language used by the parties, if we're dealing with a situation where the amount that is in dispute, or forming part of our discussion at this point, is 100% prepayment, it then attracts the law of penalties. Because 100% prepayment, the courts have usually afforded some degree of protection to parties who have prepaid 100%, and then there's some issue as to their ability or willingness to accept the full performance of the contract on both sides. So that even if we're wrong, and we don't concede that we're wrong on the issue of the treatment of the 25% as a deposit, the court still has to look to equity to see whether or not, in the circumstances here, it would have been fair and equitable for Mr. Newitt to simply be allowed to keep 100% of the rental income in the circumstances. And in a situation where he has not actually counterclaimed in the matter damages arising from the other side's refusal to stay in the property. So that we have a situation where all of the leverage, if I may use that term, resided on one side of the equation. And we say that the court needs to look very carefully as to whether or not that ought to be a situation which ought to be countenanced. Now, of course, there's also an additional issue which, while not frontally before the court on this appeal, was the fact that Mr. Newitt did in fact rent the property out to another set of visitors, the sum of $5,000, and kept that money basically because he tendered a check and then put a stop payment on it. So we have a situation in the appeal where Mr. Newitt kept 100% of the money from the Brookses and the rental income which was generated during that period. Now, that doesn't form, as I said, part of the appeal which is frontally before the court, but it is one of the things which I would submit that in equity a court would be entitled to look at given the circumstances in the round. So that at the end of the day, what we're asking the court simply to do is to hold the parties to what we say was their actual arrangement. 25% non-refundable deposit, and an implied term that on arriving in Barbados, should there have been an issue with the accommodation, that the term or the percentage of that prepayment, which must now be referred to as a refundable or possibly refundable amount, would be refunded. Now, the reason additionally...
Sir, before you go further, just to go back to the rental out to the third party, if you will, you said it would not be fair and equitable for Mr. Hewitt to keep the 100% consideration. Now, could that point be answered by reference to the law of mitigation? Because it is not fair and equitable for him to keep that, but he's under an obligation to mitigate any loss that he might sustain by renting out the property as best he can.
Yes.
So that it is fair and equitable to keep the 100%, it could be argued, because he has this duty to mitigate. And if he cannot mitigate, then obviously he's entitled to keep the 100%. But if he can mitigate, then to the extent of the mitigation, that 100% is reduced accordingly.
Yes, that is, if there was not the prospect or the specter, if I may use it, that term, of how these parties actually concluded their agreement. And one of the and I'll keep coming back to the law of deposits and penalty, because once a court accepts that a portion of the consideration was paid as a legitimate deposit, the person who is the innocent party to the contract is allowed to forfeit that deposit without having to prove the extent of his loss, and then can proceed in the circumstances here. Had Mr. Newitt been able to, on the second day, the very next day, rent out that property for the entire period that the Brookses should have been there, he would have been entitled to keep the 25% non-refundable deposit and the full amount for a subsequent rental. And that is why the treatment of the prepayment as a deposit is so critical to the appellant's case, because you have to look at it on both sides. Mr. Newitt was put in a position where he could take 25% from the Brookses and a contingent 100% from another renter, and not have to refund the 25%, because that's the purpose of a non-refundable.
I understand that perfectly, but of course the tourism industry, common knowledge, is a very volatile industry, and there is no assurance that Mr. Hewitt or Newitt would have been able to find, another person to use the accommodation at such very short notice. Are you saying that's one of the risks that's run in the industry?
Indeed. And what I'm saying is, beyond that, Your Honor, is that these parties were very careful, albeit not in a one document, in the exchange of emails, which forms part of the record in this appeal, the treatment of the prepayment, the non-refundable deposit, and the remainder were very specifically dealt with. And I made a submission in the written submissions to say that if Mr. Newitt wanted to further protect himself, as often renters now often do, he could have inserted a term in those conditions to say, in the event that you come to Barbados within, or you choose not to stay within 2 weeks of arrival in Barbados, you forfeit either the entire 75% that you've prepaid or a further percentage of that. But he didn't. He was silent on that point. So he's bound, we say, by the use of his own language in his emails to the Brooks family.
Mr. Weeks,
Yes.
I'm trying to get grips to the legal foundation of your claim. For example, you were talking about the deposit as a pre-estimate of loss to be suffered in the event of a breach of contract and all of that. A lot of when we talk about mitigation of damages, that all supposes that there is a breach of contract. Now, in this particular case, is there a breach of contract, and by whom? And what is that breach? Because, as far as I can see, Mr. Brooks wanted to have this property for a few weeks. He paid the price. He paid the full price. So he did his part of the contract. And Mr. Newitt had to make available the property for a few weeks, which he did. Now, if I rent a house for a year and I choose not to live in the house, that's my problem. I still have to pay. And so this is, you could say, well, Mr. Brooks' problem. He saw it for whatever reason. And that reason is not a breach of contract, because there's nothing in the file saying about that. He chose not to go into the property, which is his business. That is his problem. But he paid, and the owner of the property did his part of the contract. So, first of all, is there a breach of contract? If not, can we then speak about loss, damages, etc.? In fact, Mr. Newitt had no loss, so that he had not to mitigate anything because he got the full price. So that is somewhat confusing. Now, unless, and I think I hear you saying that too, no, this contract needs to be interpreted differently. You have to read in a few implied conditions if you wish. So if you say, well, this contract, and of course then you have to reason that this is a contract where you pay 25% deposit, which is non-refundable. So, and then when you come and you don't like it, and then you can get the rest of the money. Then you don't have to pay the 75%, or in this case, you can get it back, unless the other side will rent it out and get money from that. Then you would interpret the contract in a certain way, and then you don't need breach of contract, or you don't need damages. So what is it that is the legal foundation of your claim as it stands now? It cannot be both. So I need to know clearly what is the legal foundation of your claim.
The legal foundation, if I had to submit only one argument, it would be that, and it would be based on the requirement of the court principally to imply a term into the contract, as I alluded to before, that because of the language actually used expressly by the parties and the circumstances of the type of arrangement which was entered into, it would be perfectly reasonable and to give business efficacy to this arrangement for the court to imply a term which said that upon arrival in Barbados by the Brooks family, if for any reason they chose not to avail themselves of the residence and did not stay in the residence for a single night, that they were open contractually to demand a refund of the 75%, which has been expressed to be refundable because of the actual terms used by the parties, by extrapolation. So it is breach of that implied term that would give rise to the obligation of Mr. Newitt to refund the money to the Brooks family. But in addition to that, there is a principle of law which, beyond pure contractual principles, that when a party who is required to and does make a very, very substantial prepayment, and in this case 100% prepayment, the law and equity look very carefully as to whether or not that party should be subject to losing 100% of the money which they have prepaid without enjoying, by their choice, the benefits of the contract. And there is a statement in one of the cases which I put before the court, and I'll find it for the court. Yes, there's a statement of Lord Denning to be found at page 1064 of the CCJ record. There's actually, it's from the case of Stockcloser and Johnson, which is to be found, Lord Denning's judgment is to be found at 1061 to 1064 or thereabouts, or 1065. But the reference that I wish to refer you to is on, there are two. One, the first is on page 1063. And it reads, readiness and willingness is essential in specific performance and relief from forfeiture of leases, but not in relief from forfeiture of sums paid. And then on the next page, at 1064, he goes on to say, these illustrations convince me that in a proper case, there is an equity of restitution, which a party in default does not lose simply because he is not able or unwilling to perform the contract. Nay, that is the very reason why he needs the equity. The equity operates not because of the plaintiff's default, but because it is in the particular case unconscionable for the seller to retain the money. In short, he ought not to unjustly enrich himself at the plaintiff's expense. He then goes on to say, suppose, for instance, that in the instance of the necklace, which was an example he had given just before, the first installment was only 5% of the price, and the buyer may default on the second installment to be repaid to him any more than he could claim repayment of the deposit. But it is very different after 90% has been paid. So when a party to a contract has paid the vast majority of the consideration, and in this particular case before the court 100%, the court has to see that whether in the circumstances in the round, it would be permissible to allow the other party to keep the money, even subject to the principles of mitigation of damage. So the main plank, just to summarize, I had indicated that I didn't intend to stray too far from the written submissions.
Mr. Weeks, before you summarize, you spoke about unconscionability. Are you saying that in these types of contracts that the person could come from abroad, the place is in perfect condition, and the person may just not like something about it and go to another place, and you say that it is unconscionable in those circumstances for the owner to demand payment for the days that have already been agreed to? You find that an unconscionable situation, Mr. Weeks?
Not as expressed by your ladyship in those very limited terms. What I am saying
But
is
before
that
you go to that, before you go on, was not what the trial judge found? Because as I look at your case at the beginning, your case was about breach of contract by the owners, not about a situation where your client was in breach of contract. And as I understand it as well, the trial judge ordered that $5,000, which had been received for those days, to be repaid to your client with interest. I don't think that has been touched by the Court of Appeal.
No, Your Lordship. Two things on that. The situation which Your Lordship painted or set out, I could not possibly argue that it would be unconscionable for the owner of a property to keep a portion of the money or in some circumstances maybe even all of the money for the agreed period of time. But what I am saying is that on the circumstances of this case, given the arrangement which the parties have entered into, the language that they have used in coming to their arrangement, that it would be unconscionable in the circumstances in the round here for Mr. Newitt to have been allowed to keep 100% of the agreed sum, subject only to his duty to mitigate. So this is a factual matrix which has to be looked at in our submission in the round. And for justice to be done, I think that there is no other way that the court can approach the matter. Unless I can be of any further assistance to the court.
Yeah, yes, you may, for me anyway. Just a practical question. In monetary terms, how much would 75% be that you're asking for?
That would be approximately 8,000 odd US dollars.
Yes, so that's just basically 3,000 more than the 5,000 that the judge ordered to be paid to your client.
Yes,
so you're fighting really for
true.
a point in principle, not so much for the monetary amount, because I would have thought the difference between what the judge said that you're entitled to and what you're saying that you're entitled to, is not that much.
The 5,000 was Barbados dollars, and the 8,000 that I referred to was actually US dollars. So it's actually 16,000 Barbados dollars. The difference is actually 11,000. It's a bit more significant than 3,000. But I agree.
Fair enough. Point taken. Thank you.
Just before you take your seat, Mr. Weeks, the authorities to which you have adverted, they all seem to deal with sale of land or sale of an asset. Don't you see that there is a very significant difference between the sale of an asset and what essentially is sale of time and a lease, tenancy?
Well,
do you have any cases where that principle that relates to the sale of land or sale of an asset, as in Stockloser and Johnson, which had to do with sale of plant and machinery, where those principles that you espouse have been applied to tenancy arrangements?
Your Worship, I was not, Your Worship, Your Honor, I have not been able to find a case which is on all fours with the factual matrix as presented in this case. The closest actually was my learned friend's authority, which she cited to the court in her written submissions. But the difference, as I pointed out, and I think I pointed out in my response, was that was not a case where 100% of, or even close to a significant amount of the rental which had been agreed in that case had been paid. What happened in that case is that there was an arrangement for the rental of a property. Again, the renter took issue with the condition of the property and went and stayed somewhere else, and then sought to recover the additional expenditure, or the difference between the expenditure between the two sets of accommodation, and the court held that he couldn't. That is different to the situation here. And as a principle of law, I cannot see that there can be a meaningful distinction between the purchase of time, which in this case, which is it's a relatively short period of time, but it is a form of proprietary interest. Because once I've acquired the right to enter into a property for a stipulated period of time in exchange for consideration, that is a form of property right. It might be a limited one, but it is a form of property right. Now, the CCJ, your court, they deal with the issue of the deposit in one of the cases which I submitted to the court, and it involved, I believe it was the lease of a helicopter.
The facts in that case were very complicated and very different, Mr. Weeks. You can't compare the two.
Yes.
But I'm surprised, and it is probably because you are solely focused on looking at this case from your client's standpoint. But I'm a little surprised that you cannot appreciate the significant distinction between the sale of land or the sale of an asset and a tenancy arrangement. Where you have an asset being sold or land being sold, if the agreement goes sour, the vendor still has the asset or the land so that they can deal with it a second time. Mr. Newitt and his wife can't rent that place a second time for the period for which Mr. Brooks and his family wanted it. That period is gone forever.
Your Honor, with respect, it is gone now by a fraction of time. The point in time which I would humbly submit to the court is relevant to the consideration and the analysis is when the Brookses arrived, it was still possible for Mr. Newitt to have rented that accommodation out, possibly for the entire period of time for which the Brooks had ostensibly rented it. And as Justice Anderson had indicated, one of the risks that the person in Mr. Newitt's position accepts is that when he entered into the contractual arrangement, which he did, and entered into the terms which he did, he, in our estimation, agreed to accept that 25% of the agreed consideration was, no matter what happened, going to be his to keep. That guaranteed him against the contingency of the Brookses not being able, or for whatever reason, to accept the property. So, if this contractual arrangement had been agreed to using different terms, I would be in entire agreement with your Honor. And I've tried to look at the situation from both sides, because I come back to the point: what would have happened? And again, it's a hypothetical situation just to tease the point out. What would have happened had the Brookses arrived at Desert Rose and there was a legitimate reason why they couldn't stay there, not the fault of either party. For example, one of the Brookses' children could have been allergic, for example, to a piece of flowering plant that happened to be there that they did not know of. Is it right in those circumstances that Mr. Newitt could have insisted that they stay in the property because he was nevertheless making it available to them? I say no, and that is the reason why the parties entered into the arrangement contractually, which they did. Because both parties were protected to a large degree, one by a non-refundable 25% deposit, and the other to the benefit of an implied term saying that if we get there, because we didn't see the property before, and something happens, we can have the security of knowing that we will get our money back, or 75% back, and possibly stay somewhere else. So I have tried to find a balance between the consequences for both parties on the facts and the arrangement actually entered into between the parties. It's not a straightforward issue to resolve, but I hope I've done an adequate job in trying to explain Mr. Brooks's position on the facts and the law.
One further line of inquiry, if I may, Mr. Weeks, and I think you have done a very good job of advancing your client's case. I see where the correspondence, in particular an email of the 21st June 2005, identifies that there would be a 25% non-refundable deposit with the balance due 8 weeks prior to your arrival. And the implication which that is raising in my mind, and I need your assistance, is you deposit 25% now, and that is immediately non-refundable. That is the cost of my committing myself to having this property available to you. 8 weeks before, you need to pay the total price. If at that 8 weeks period you do not pay the total price, your 25% deposit is gone. So it is a staged payment, and the 25% is not non-refundable at the point in time of non-occupation or rejection. The 25% is non-refundable from 8 weeks before the rental is to commence. Does that make a difference?
In my humble submission, no, it would not, Your Honor, because the condition of paying the full, the remaining 75% 8 weeks before arrival is not in and of itself a discrete contractual arrangement. In my humble submission, the arrangement must be looked at for its effect in totality. Because if this had been a situation where the Brooks family had seen the property, had there been a local family, for example, and they had had the opportunity to view the property, accept it as it is, and have entered into the arrangement, whatever arrangement they wanted, that would be one thing. But the reason that I'm submitting that the case needs to be looked at in the round is that you have a family coming over the seas to a site unseen, having agreed to pay their entire consideration, but agreeing that 25% of that payment would in no circumstances be recoverable. And it's not recoverable simply from the time when the time for the payment arose. Because once they made that 75% final payment, in my estimation, they didn't lose the protection of their having prepaid a non-refundable deposit.
They didn't lose. Sorry. Who did not lose?
They didn't lose the benefits of it.
Oh, the protection, the benefit.
The protection of having paid a deposit.
There is no protection. There is no protection for them, Mr. Weeks. The protection is to the renter, the owner. I will not market my property. I will not market my property because you have paid me 25%, and therefore that binds me. I regard myself as bound because I have a 25% non-refundable deposit. That is what binds me. To take it further, to keep myself bound, I need you to show that you are fully committed to this thing by paying me everything within 2 months before you arrive. So 2 months before you arrive, the place is yours for this period, and the rent is mine for that period. End of story. You choose when you arrive not to inhabit, as my brother Witt indicated. That is your choice.
Except, Your Honor, that is not the language actually used by the parties to the agreement. Because the overall rent, or the rental consideration, was stated as $11,000 US.
Yes.
Broken up into 2 payments. So it was not as if it was treated as a reservation deposit. That would be different. I would concede to your lordship, your honor.
But sorry. I'm looking at the language of their email. It's at page 257 of the record. The language of the email is 25% non-refundable, and then the entire balance, 8 weeks.
page, I had made a note of it myself, Your Honor.
257. The CCJ record.
Crazy court's indulgence. My computer is not cooperating with me.
That's all right.
But fast.
It's from Harry Newitt, sent Tuesday, June 21, 2005, to Susie Brooks. Subject, an inquiry about holiday rentals, etc. Hi Susie, thank you for the interest shown in Desert Rose. It is certainly an ideal spot for your vacation. The total cost for the 16-day period requested would be $11,750 US, inclusive of that. To secure your booking, a 25% non-refundable deposit is required, with balance due 8 weeks prior to your arrival. Payment to be made by bank transfer to a bank account provided. So it's to secure your booking.
But Your Honor, I have always relied, whether correctly or incorrectly, on the sentence which comes before that. It says the total cost for the 16-day period requested would be $11,750 US, inclusive of that.
Right.
To secure your booking, a 25% non-refundable deposit would have to be of that amount.
Right.
It's required with balance due 8 weeks prior to your arrival. Payment to be made by bank transfer to a bank account provided.
Yeah.
So the interpretation given to this document by the appellant was that they were making a non-refundable deposit, 25% of that $11,750, and that is exactly what happened. They paid 25% of that, and then 8 weeks in accordance with the requirement, they paid the remainder, and which satisfied Mr. Newitt. So we've always treated the $11,750 as the overall agreed amount, and that the 25% non-refundable deposit was a portion of that $11,000.
Right. And
whether we were right in doing that.
But I share your view. So we interpret it exactly the same. So what difference does that make? You pay 25% to secure your booking. So I'm taking you seriously. I have made this booking for you. And then the crunch time is 8 weeks before. Pay me everything.
Yes.
And it's yours.
Yes. Indeed. Except, and that's factually, that comprises the factual matrix. What the appellant is submitting to the court is that there are legal consequences which attend the use of the language by the parties in their contract. There are certain legal consequences when you use the term deposit, and there are even stronger consequences.
We are very familiar with the notion of deposit, etc. 10% in the case of land sales, etc. Those are all of them.
Yes, Your Honor. So that is how we on this side have always assessed the legal position.
I have your response very clearly. Thank you.
Your Honor, if it can be of no further assistance to the court, those would be the submissions on behalf of the appellant, Mr. Brooks.
Yes, thank you very much. Ms. Devonish?
Your Honor, similarly, with respect to my written submissions submitted to the court previously, I wish to stand by them. And there is not much I wish to say at this point, considering the thorough investigations of some of the issues, or the two specific issues raised by counsel. The first being with respect to the implied term, and with respect to this said email of the 21st June 2005, I would wish to urge the court to disregard counsel's argument as baseless. I wish also to ask the court to disregard counsel's argument that any tourist can turn up on your doorstep after making an agreement such as this one. And for any reason whatsoever he doesn't like your property, he can just walk away. That does not contribute to good business practice, and it clearly would refer to chaos in the market. The issue of whether the appellant was the innocent party or whether the respondent was the innocent party, I wish to draw your attention to the fact that both courts, the lower court and the Court of Appeal, upheld the facts.
Counsel, to Mr. Weeks' credit, he does not go into that. He does not go into at all the question of who was the innocent party.
But sir, in terms of the question of the consideration, in terms of the fact that underpinning the implied term, one has to look towards the fact that the visitors, what he's saying is that the visitor comes, the visitor doesn't like the premises, and for whatever reason, they're entitled to a refund of the deposit or the balance of the deposit, give and take that he's conceded that the 25% deposit is going to be forfeited. The question, to me, in my opinion, would be based on whether there is whether the appellant in this case has a basis for turning away from the agreement. And I'm saying that once he turns away from the agreement in circumstances where there was a breach.
Why are you opening that door to Mr. Weeks? Mr. Weeks is not advocating any factual basis which entitled his clients to refuse the rental. Mr. Weeks is saying, my client refused the rental, and it was an implied term that whatever the damage, and there he is conceding damage, whatever the damage and whatever the damages which flow, it should be limited to 25%. So he is conceding damages. So he is implicitly accepting fault on the part of his client. So I suggest you leave alone the factual matrix, as you put it. My view.
Much right, Your Honor.
Okay.
But in order to justify the point that he's taking, he's saying, okay, he's conceding that my client was at fault in not taking up the accommodation. However, he did indicate a sort of hypothetical situation where, for example, the children of the visitors coming in were allergic to something on the property. In those circumstances, is it still your case that the entire 100% consideration ought to be forfeited, even though these visitors cannot, for good reason, not having to do with the preparation of the premises, but for good reason, could not stay there? And what is your response to that hypothetical that he gave you?
That the respondent in that situation
yes.
is nevertheless entitled to the 100%. In similar circumstances where, as Your Honor as your brother pointed out, if the premises had to be rented and for whatever reason you didn't like the noise or whatever reason it was outside of your control at the time of rental, the rental agreement would still have to be honored.
So caveat emptor.
So yes, Your Honor.
Except
so
in this case, the buyer would not have had a chance to examine the goods.
The buyer in the circumstances who is overseas can never be in a position, to consider all the local circumstances that might go, that might be prejudicial to their stay. Yes. They might be allergic to the seawater, to the salt, whatever. So the considerations could be endless, but the principle, if that is what we are trying to establish in circumstances where you have a tourist market, where you have local owners relying on tourists, they don't know who these people are. Mm-hmm. They can only rely on a business relationship where you pay a deposit and you pay the balance of the rental agreement fee to come. That is reasonable. That is the market conditions that we are in, and I therefore would think that it would be very prejudicial to owners if they were not to be allowed to forfeit sums of money that have been prepaid in circumstances where what would happen? The visitor turns up, the visitor doesn't like the situation, the visitor may claim they don't like the situation because maybe they've seen something else and whatnot, and then you're left hanging.
Hanging to the extent that you can't claim the 75%, but there'll certainly be. But I hear you. Do you think that the contractual arrangements that were made between these two parties is the optimal arrangement that could be made, should be made in this very sensitive industry? It's clear enough that 100% ought to be forfeited in the circumstances, or do you think that clearer terms might help to give more certainty to the industry?
Clear terms will clearly give more certainty to the industry. But in the era where we have people advertising on the internet,
yes,
where we have people having easy, unofficial email communications, like "Hi Susie," or secure your booking at 25% on deposit. I think that has to be taken into consideration. Those types of communication.
And of course, Ms. Devonish, this is not 2005 anymore. So you have Google Map and all of this sort of thing. So Susie could, in this day and age, now look and see that it is not on the beachfront as she may have thought, and the disappointment could have been entirely avoided.
And the fact that it never said in the contract that it was on the beach.
That's not the point.
That's
not the point. The point is that Susie would have known and would not have misled herself.
In the present
yes.
in these present.
So things have evolved.
Yeah.
Just another point, ma'am. I think your client was ordered to pay $5,000. I hear now it's Barbados dollars plus interest. Has that been paid?
No, Your Honor.
And why has that not been paid?
Certain monies have been paid into court, but we haven't resolved the matter at this moment. But
there was no dispute about this. You never.
There's no dispute about that. There's no dispute about that, Your Honor.
Yes, but if there's no dispute about it, and there's interest running, and then that amount will only get bigger. So is it not in the interest of your client to pay it as soon as possible?
I think, sir, there was issues where the client had died, and then the executor took over, and then the matter became live again.
Okay. But the fact that he, just in terms of the contract, under the circumstances as they occurred, do you think that your client was obligated to find somebody else to rent it out to, and or is this something he did maybe he was not obliged to do under the circumstances?
In the circumstances, he did that.
Yeah, we know that he did it, but in your view, when you look at the contract, was he more or less compelled to do that? Or
having faced with a situation where he
got all the money, so he got all the money for the period, so he could have said, well, I have the money, why should I make any efforts to rent it out to somebody else and give that money then to the other side? So my question is simply, we know that he did it, but in your view, when you look at this particular contract, was he more or less compelled to do that? Was he obligated to do that? Or was it just a nice gesture of him?
In the circumstances, I think he was obliged.
He was obliged
to do what he had to do.
Okay.
And
so why was he obliged?
Well, in circumstances where he's a businessman. He has the property there prepared, and I think he just simply went ahead and did it and advertised and.
Yeah, I know he did it.
Investing in the circumstances. Thought that in the best circumstances, that he could put himself in a position to get back to the respondents in circumstances where he did not lose.
There's such a thing as anticipatory breach. So the breach can occur even before the contract period. And if the breach occurs, my understanding is that the innocent party has a legal duty to mitigate its loss. Not so, Ms. Devonish?
Yes, Your Honor.
Okay. Yeah, and that would be a very good rule if there was loss. But your client didn't have any loss because he got paid. And as far as I can see, there was no breach of contract by anyone, as far as the facts go. Mr. Brooks paid everything, and your client made available the house for the period requested. Now, I was just curious to see when everybody would agree that it is a good thing that he tried to rent it out to somebody else and give at least that money could go back to Mr. Brooks. But as we are now discussing what kind of contract and what implying terms are there or not, I was interested to see what is your view on what he did. Is that an obligation, and on what grounds does that obligation exist? Anyway.
Of course, Mr. Weeks' theory of the case is that your client was entitled only to 25%. So that he didn't have the full consideration. He wasn't entitled to the full consideration. There was a breach, and therefore he was entitled as far as possible to mitigate that loss for the 75%. But I think we're probably taking you down a rabbit hole that I'm not sure you need to go down.
Yes. Ms. Devonish, you mentioned that, did I hear you right, that monies had been paid into court?
I stand corrected there, Your Honor.
Sorry?
I stand corrected, Your Honor.
Oh, okay.
They have not been paid into court, is that it?
It is not the case, Your Honor.
Okay.
So the 5,000 Barbadian dollars plus interest would be still outstanding.
To the best of my knowledge,
Thank
Your
you.
Honor. Your Honor, I urge the court to, in these circumstances, uphold the decisions of the First Instance Court and the Court of Appeal, and I have no further contributions, submissions to make at this stage.
Yes. Thank you very much.
Thank you, Your Honor.
Thank you.
Mr. Weeks, do you have any short response?
With the emphasis on short.
Your Worship, I don't know. Through the indulgence of the court just inquired in relation to this $5,000 payment. As a matter of fact, the $5,000 was tendered before the Brooke family left Barbados, but a stop payment was put on the check. So just for the sake of completeness, that is what occurred on that, in relation to that $5,000.
Was there any explanation ever given for the payment being stopped?
None whatsoever, Your Honor.
I see. Okay, so that's it? Okay, we take a break for 10 minutes and then we'll come back and let you know what the position is.
Court rise.